your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. Ladies and gentlemen, I am your host, Daniel, and today is Judge Aaron Gauthier court docket. Now, I'm not going to be watching the chat. I got to watch the YouTube that I'm playing because I have to skip ads. I actually got struck for an ad, the music in one of the ads, so I got to kind of be careful of that. If I see the ad, I'm just going to mute it. I'll stop it, mute it, so that it doesn't play. If you guys like this content, please let me know that you like this content. It seems that YouTube is just getting more and more ridiculous with their garbage. Now they say that if you're in the chat, if you're watching this, it's not considered a live, or it's not considered a watch or watch time hours if you're sitting and watching this without typing in the chat. And I think that's ridiculous. My numbers have gone down so much. I was at almost 600 watch time hours. It's ridiculous. So I might be stepping away for a while. I don't know. I haven't made that decision yet. I mean, these people are just getting worse and worse and worse with their stupidness. Yeah, they can't stop. They won't do anything about a trash channel like Two Fleas. All right.
Yes, we
All right, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access to this hearing both in the courtroom and also online. And up next, we have Sterrett B. Benson, file 24-9023CZ. Counsel, you want to state your appearances for the record, beginning with plaintiff.
Good morning, Your Honor. Kevin Cleaborn. I represent Michael Sterrett, who's to my left. Francis Sterrett is in hospice, is not present today. We'll also have David Sterrett, the one who signed one of our affidavits in the rear of the court.
Okay, thank you. Good morning.
Your Honor, Kurt Thornblad on behalf of Dr. Philip Benson. Mr. Benson is also present on Zoom. The court indicated that the hearing today would be on Zoom.
Okay, thank you. And yes, Mr. Benson is in the hearing. His audio's on, his video's not on, and that's certainly fine with me. All right, so this is plaintiffs. We're up for a final pretrial, but we have plaintiff's motion for summary disposition. I have reviewed the motion, response, and reply, and all of the attendant exhibits. Thank you both for setting forth the facts and the law in a way that I could understand what the case was about. So, Mr. Cleaborn, go ahead and argue your motions.
Thank you. Your Honor, I think I would probably be well advised to do the counterclaim by the defendant first. It was filed after we took his deposition. It was clear in his testimony that there was certainly a long period where he was kind of missing in action, but most importantly, his counterclaim that repeatedly said everyone used this cabin, everyone had a key, et cetera, certainly shows that there was no exclusive use, there was no hostility, and so I just didn't see any substance at all to the counterclaim, and so that's why we asked that the counterclaim that was just filed July 3rd be dismissed. If there are any other questions about that, I'm happy to engage, but I thought I'd spend most of my argument time on the delivery of the deed issue.
Sure, I think I understood his argument on the counterclaim to basically be, because we've got a little bit of a weird factual crevice that this case fell into, that for the last more than 20 years, everybody has believed the two plaintiffs and the defendant to be co-tenants because of the deed, and the problems with the delivery weren't revealed until much later.
Right.
So I understood his counterclaim to basically be some kind of way to attach a legal theory to acknowledge that if I've been treated as the owner for 20 years, shouldn't I be the owner? Why should that not be?
Well, I thought that was more of an estoppel argument as opposed to an adverse possession claim. I thought his claim with regard to acquiescence, that's a boundary dispute. The acquiescence theory does not apply at all in this case. So I thought his estoppel argument may have had more wind in the sails, if you will, if, again, the defendant had been chipping in his 1/3 over 25 years.
Or if your clients had known about the delivery problem and done nothing about it.
Correct. And if then, he chipped in his 1/3 and now he raised the issue of the delivery of the deed, well, I can understand an estoppel argument better then, but he hasn't been chipping in. And so I just thought that the estoppel argument didn't resonate with me anyway.
Okay. So can I ask you, so you're, and maybe I'm jumping the gun getting into your main claim. My principal question is, so there's this deed that puts your two clients and Mr. Benson as co-tenants, that then appears to be undisputed that deed was never recorded or delivered to any of the grantees before the grantor's death.
Correct.
And so black letter law would be that deed was in effect. So, and you've attached a will that would have your two clients be the devisees of that property. And as I understand the law, black letter law, that the property would transfer at the title of real estate passes at death to the heirs or devisees. But was this will ever probated, or?
There was a Wayne County probate action that was opened up, and then it was closed administratively in about 2005, 2006, somewhere in there. I just checked the register of action in Wayne County.
But the will was submitted to probate.
Correct, it was. But once, by 2004, 2005, when this deed sort of appeared, they just sort of abandoned the probate claim and let the probate court in Wayne County close out that proceeding.
So if you prevailed on count 4 is to declare the deed invalid because it was not delivered or recorded before the grantor's death.
Well, that was correct. And I guess I didn't see that the affidavit that was, again, whether it was signed in front of a notary or not, that's more of a technical issue, but the defendant repeatedly testified that he knew absolutely nothing about the deed, didn't even know where it was, didn't know who had it, etc. And it was only 25 months plus after it was recorded. It was again recorded 25 months after Wileen Sterrett allegedly signed it, that his mother showed him a copy of it. Well, and again, I covered that ground as thoroughly as I could, and then to have an affidavit say, well, gosh, Wileen gave it to my mom. Well, he didn't testify to that. He had no idea whatsoever where that deed was. And so that's why we, in our reply, said that's just a bad affidavit. You're trying to, grasp a Hail Mary pass here to avoid summary disposition.
If you prevailed on count 4, what would that do to your remaining counts going through 3?
Well, I think the only thing that we would have is, again, our original complaint pled the statute with regard to the court, I think, would need to issue a writ of restitution type thing with regard to restoring possession to us. Again, the affidavit of General Russian, for example, last week, it was just fortuitous that when we got in the reply brief that she was up here staying with my client, Mike Sterrett, she would have used the cabin but for the defendant's occupancy. And so I think under the statute, section 3 of MCL 600.2932, the court can issue, a writ of possession restoring us. And then even under the court rule 3.441, I think it's sub C, the court can set a hearing with regard to his possession as squatting, if you will, over the last year.
Sure. So that goes to what remedy you're seeking.
Correct.
But my question is, you had 3 other counts for contribution, for adverse possession.
Yeah.
So if you win relief on count 4, counts 1 through 3
I think the rest
are moot. Okay.
Yes, I think they're academic.
So my other question would be, if you prevailed on count 4 and the deed is invalid, and I imagine then a judgment, you'd want quieting title in your clients, would that be tenants in common then, because it would have passed through a will, and then if they want some other co-tenancy, they'll have to execute the
I believe that
necessary
would be
documents?
correct. Yes, that would be the result under the will. Anyway,
Okay.
yes.
I didn't mean to short circuit you.
No,
anything else you want to argue with that? Go
I
ahead.
frankly rather scratch where you itch than just yammer on without any kind of, I guess I think the only thing I guess I would draw the court's attention to is plaintiff filed this motion, and then the defense in their response raised, again, a number of issues. One of the cases that they quoted, Cook versus Sadler, they quoted it 4 different times. I think trying to argue that a mysterious delivery of the deed, who knows, to the defendant's mother somehow was an escrow type thing. And so, again, because they quoted it 4 times, the only comments I'll make about Cook v. Sadler against a 100-year-old case. But in that particular case, there was a delivery of a deed with specific instructions. Don't record this until after my death. So A, there were specific instructions. We have none of that in this particular case. The father and mother actually told the son at issue we're going to do this, son, and it'll be recorded after death. So there's none of that in this particular case. The son went ahead and built a house on the property, and then he planted orchards on the property in reliance on that. So it was kind of, again, an estoppel type case. And so, again, I just didn't think that, the escrow argument had any kind of merit, but again, it was more in that particular case that they quoted 4 times, the son actually relying on what was promised. So I just thought that that was a case that should be distinguished. So anyway, that's the only comments I'll have. I'll wait till defense counsel responds and save my time for that.
Thank you, Mr. Klevorn. Mr. Thornblad, what's your response, sir?
Well, Mr. Claiborne wants to do the adverse possession issue first, so we'll do the adverse possession issue first. But I'll also reference the theory of that you can give a deed to an agent in order to record it or deliver it later on. Now, obviously, the grandmother gave my client's mother access to her paperwork, and that's pretty well established. And then the mother went forward and recorded the deed. Now, we have in this state what's called a presumption, which favors the defendant in this case. That's a presumption of legality. So it would be presumed until it is shown otherwise by the plaintiffs that the mother was acting under the direction of the grandmother. But even if it were not the case, even if that were not the case, to get back to adverse possession, it's still a color of title. It's an open and notorious act that was done more than 15 years ago. A number of people in the family have used the property, but that's consistent with the grandmother's general proposition that the title to the property should be held generally and shared and used by those who need it. The acquiescence theory goes to.
Can I ask you? If the use has been communal, how could that establish adverse possession against co-tenants?
That's the acquisition theory under the case of Houston versus Mint Corporation. And it's also consistent with the doctrine of tacking. So my client may not have been in this property for 15 years, but he can tack onto the usage of other people, and that's the same as the acquiescence theory.
Okay, thank you. Anything else you want me to know to understand your argument, sir?
Yes, I will. Even if it's not a proper deed, it's still a testamentary statement, and deeds have been used as testamentary declarations. I would add that if, in fact, Mr. Claiborne and his clients prevail on this issue that there is no valid deed, then his clients do not have any standing to come forward. It has to go back to the probate court. You can't quiet the title. Other things can come up. The deed is dated after the will that's being cited by the Claibornes. The later testamentary act is the one that governs. It has to be if you decide as a matter of fact today that the deed is an invalid deed, then nobody has title to the property until it goes through the probate court.
All right, thank you. Any rebuttal, Mr. Cleveland?
Thank you, Your Honor. Now, obviously, on the deed issue, it is the burden of the defendant to prove delivery of the deed. If he's going to rely on it, he has to prove it and show that to the court's satisfaction, and there's really nothing whatsoever. With regard to the adverse possession claim, when the defendant at his deposition testified that after his grandma died, there was social drinking that offended him, and he, quote, never spent a night there. Well, again, that just kind of boggles my mind that you can advocate then an adverse possession type claim. And then lastly, with regard to the testamentary nature of a deed, I mean, that argument just makes no sense when Wileen retained a life estate. I mean, there was nothing on the deed that said it's going to take effect, when I die and when I die only. So I just can't appreciate that argument. So again, lastly, the Houston case, that's why I attached a copy of the survey and the picture. It's an acquiescence boundary line dispute case. You know, the garden was over the line, and so acquiescence just has no relevance whatsoever to this proceeding. And I ask the court grant our relief.
All right, thank you. Well, there are some facts for which there's no real genuine issue here, as follows. On July 28th of the year 2000, there's a quitclaim deed from grantor Wileen Sterrett to 3 grantees, the 2 plaintiffs and the defendant, and reserving to the grantor a life estate. And also that deed was not delivered to any of the 3 grantees before the grantor's death. The deed was not recorded until August 26th of 2002, again after the grantor's death. The defendant's deposition testimony establishes that he was unaware of the deed until after its recording, and he did not know where it was before then. Defendant now attempts to contradict his sworn testimony by an affidavit that the plaintiff says is improperly signed. But even if it were properly signed, this is not permitted to fix. You can't fix your deposition testimony under oath by just submitting a written affidavit saying, nuh-uh. And also the claims contained in that affidavit were flatly contradicted. The claims in his affidavit about what Ms. Ruskin said were flatly contradicted by a properly executed affidavit from Ms. Ruskin saying, no, I never said that or never understood that. Also, from 2002 onward, the defendant did not use this property much at all. There were reasons why he didn't want to be there relating to alcohol use or other things, or reasons personal to himself. He didn't want to be there. He also did not contribute toward the upkeep expenses in any significant way, perhaps an isolated instance or de minimis fashion. Didn't carry his share of the load as one of 3 co-tenants under that deed. After apparently sometime during or after the COVID situation, defendant was evicted from a home and has used the cabin as a residence in a manner that has prevented its communal use by the plaintiffs or by other family members. So those appear to be largely undisputed facts. The legal analysis would be that the deed that was undelivered and unrecorded before the grantor's death was in fact ineffective to convey any property interest. A deed must be delivered to be effective. The defendant tries to argue that it was placed in some sort of escrow and therefore delivered, but the facts don't support this theory at all. There's no evidence or testimony or any indication of any escrow agreement or any terms of what that escrow would have been. In fact, and this ties into the defendant also says the deed was testamentary and is therefore an amendment or codicil to Ms. Sterrett's will. But there's nothing on the deed or in the record to support this claim. In fact, the deed on its face reserves a life estate to the grantor, which would be nonsensical if the deed was not intended to convey a present interest to the grantees at the time of its execution. So there's evidence that would show that it was not a testamentary deed because it reserved life estate to the grantor. There's no evidence of any testamentary intent, merely an executed deed that was neither delivered nor recorded until after the grantor's death, and therefore legally ineffective and a nullity. Defendant argues the plaintiffs should be stopped from raising the delivery issue, or that they've acquiesced in the joint ownership of the property over these 20 plus years. Estoppel would be an equitable application, and here the plaintiffs did not know about the lack of delivery until this litigation, and defendant has not contributed in any meaningful way to the upkeep of this property. So there's no equitable basis to apply estoppel here. And the doctrine of acquiescence is simply inapplicable. Acquiescence is a judicial doctrine to resolve boundary line disputes, and this is not one of those. Defendant also asserts adverse possession, but by his own testimony, he's not used what he calls this communal cabin exclusively. He may recently be doing so, but this recent use falls far short of the 15-year statutory period. Wileen Sterrett's will left this property to the 2 plaintiffs themselves. and the recent case of in re petition of Emmett County Treasurer 345 Mishap 692 in 2023 clarified, what I had always understood to be the law, but they flatly stated that yes, title to real estate passes at death to the heirs or devisees. The will still has to be admitted to probate, which apparently was, but there's nothing that the probate court does, that effectuates the transfer. The transfer passes upon death. So therefore, under MCR 2.116C10, there's no real genuine issue of material fact here, and plaintiffs are indeed entitled to judgment as a matter of law as to count 4 of their amended complaint, striking the deed for the lack of delivery. And as the plaintiffs indicated, this renders their counts 1 through 3 unnecessary. Plaintiffs are also entitled to judgment as a matter of law on defendant's counterclaim for adverse possession, which is dismissed with prejudice. So the plaintiffs are entitled to a judgment that would strike the deed, would quiet title in them and them only as tenants in common under the will, and order the defendant to vacate the premises immediately, and rendering the defendant responsible for any damage or waste of the premises. And the court would, that judgment when entered would close the case and be a final order, but the court still would of course retain jurisdiction to facilitate the adherence to the court's judgments. Mr. Cleaborn, you can submit a judgment either by stipulation as to form or under the 7-day notice. And Mr. Cleaborn, Mr. Thornblog, would they do both?
Thank you. Thank you, Your Honor.
All right, next we've got Hamilton Inn Select versus Great Lakes Marine Service, file 24-9047CK. Counsel, you want to place your appearances on the record?
Good morning, Your Honor. Mark Van Nest on behalf of the plaintiff.
Good morning, Your Honor. Brandon Wilson appearing on behalf of defendant.
All right, good morning. And last time we were here, there was one more dep that had to be completed. Is that done? Where are we at in terms of any resolution or readiness for a bench trial?
Yeah, we did conduct that last deposition about a week ago in Traverse City in person. I don't need any more discovery. I think we're done there. I do think there may be a benefit to filing a dispositive motion depending on when the court would want to schedule a bench trial. For example, if the court's preference is to schedule the bench trial, 60 or 90 days out, then I don't see the harm in entertaining a dispositive motion if the court would allow it to see if we can clean up some of the issues before the bench trial.
Okay. My general preference is a little different. I'd rather, if either of you think there are motions that could be dispositive or would narrow the issues, I'd rather hear those before we schedule the trial. I don't like to put trial dates on the books that are going to kind of be phantom dates. So we can, I can just continue the final pretrial, and you can use that time to notice up any motions that would either resolve or narrow the issues.
That'd be fine with me.
Mr. Wilson, what do you think about that?
I mean, I think just given the amount at issue and sort of the straightforward nature of the case, although I think there are factual issues, I think it'd be in everyone's best interest just to schedule it for trial. I don't, especially since it's a bench trial, I don't see the utility of going through this exercise potentially more than once.
Okay, well, how long would you all need for the bench trial?
I think a day or two max.
Yeah, I was thinking a day, maybe a day and a half.
Yeah, see, rather than put a 2-day trial on the books, I'd rather wait to see what issues we've got. So I'll continue this final pretrial one more time. I've got either September 29 That means you'd have to file your motion right away, Mr. Van Est. Are you ready to do so? Or I've got October 13.
I guess I'd prefer the 13th just to give me a little more time. I'm still waiting on the transcript from that last deposition we took a week ago.
Okay. I'm going to continue the final pretrial to October 13th at 9 a.m. and allow Zoom appearances. And you can notice up any motions from either side at that same date and time. And I'll schedule it for a bench trial at that time if the case is not resolved either by settlement or motion. All right, anything further from the plaintiff today?
No, Your Honor.
From the defense?
No, thanks, Your Honor.
Okay, you gentlemen have a great day.
You too.
Thanks, you too.
L24-9044CH. And we just did a courtroom renovation and it looks great, but I do apologize. It doesn't seem to accommodate multiple counsel super well.
Thank you. When we did Emmett County, it was unbelievable. They can make 2 out of the 3 courtrooms smaller. It's like, is that the tax dollars at work or what?
Well, part of what we did, frankly, was we made the jury box and witness stand ADA compliant, and that took up more space into the well of the court. So something had to give, and it was either the judge's bench or the lawyers or counsel tables. And so I suppose you got to show it. All right, so we are on my civil docket. I am providing public access not only in the courtroom but also online. Just want you folks to know that. And we are here today. Looks like defendants Bruckman filed a motion for summary disposition. I reviewed the plaintiff's response. Defendants Overton and Cisco filed a response in support of that. Plaintiffs filed a motion to strike that initial response for seeking relief for those defendants without a separate motion. It looks like, and there's responses to that, motion to strike, but it looks like defendants Overton and Cisco filed an amended response that maybe fixes that problem. All right, so let's have counsel state your appearances for the record, beginning with plaintiff.
Yes, Your Honor. Joseph Sias on behalf of Mr. and Mrs. Holderman.
Kevin Cleaborn, I represent Mike and Becky Buckman.
Lawrence Hanson on behalf of Mr. Cisco and Mr. and Mrs. Cisco.
Okay, and is Richard Reeves present? No, and is Doris Reeves present? Oh, Mr. Reeves is representing himself, filed a letter answer. It wasn't signed by Doris, so there was a default entered on her, but they are both in pro per. Okay, so Mr. Zayas, I guess my first question is, does the amended response address your concerns? And we're not going to hear argument about striking their initial response.
Only if, Your Honor, that the defendants aren't going to request summary disposition on their own behalf.
Well, I don't know, because I guess my other, and I don't want to jump the gun here to I want to hear argument from all sides.
Sure.
But if Bruckmans are entitled to summary disposition, wouldn't everybody? I mean, these are co-tenants.
Right. I mean, there are some similar issues. I understand that. My real issue.
Similar, how would they be any different? The court rule says if I conclude that the facts are such that, a party's entitled to judgment, then I should enter it without delay. So if Bruckmans prevail today, it seems to me all the defendants would prevail today. Why would there be any difference if they're co-tenants?
My real issue with the pleadings that the Cleburns filed, Your Honor, was the fact that they added additional arguments. In fact, even adding additional case 3 days before my response is due. If they simply filed a concurrence saying exactly what the court just said, I think it'd be a completely different situation. But when, you shorten the time I have to reply by 2 weeks by adding additional arguments and even referring to another case, then I think that's a different matter. And that is my real issue with the Cleverns trying to kind of add themselves onto this. It wasn't a simple, yes, we concur, us too. It was, here are these other arguments that why you should grant us summary disposition, which are not exactly the same as what the Bruckmans filed.
Oh, okay, all right, well, and I know there was a response to your motion to strike, and so you all, or many of you seemed to care a lot about that. I want to assure you, I cared very little about all the details of when it was filed and whatever. I read all this stuff. You all did a great job filing all this stuff. So I am much more interested today in the, you can make whatever arguments you want to make. I am much more interested today in the substance on whether the Bruckmans are entitled to summary disposition. And it seems like if they are, that's the first domino and everything falls after that. So that would mean it's your motion, Mr. Cleveland.
Thank you again. Good morning again, Your Honor. It seems like from the plaintiff's view of the world, they pled adverse possession, hostility, et cetera, time and time again. But the facts at their depositions just shout loud that there is absolutely no element of hostility whatsoever. And any kind of claim like that has to be inconsistent with the rights of the defendants. And so is there anything anywhere where the use of that drive was inconsistent with the rights of the defendants? And the answer is no. The issue of even the extension of that drive onto the plaintiff's property, Plaintiff Rich Halterman testified, well, I put that in for Mr. Covington's father, Grandpa Covington. He never said, well, I did it because I wanted to, I did it because I need to, or anything like that. The plaintiff, Julia Halterman, testified it was for the defendant's guests. And so even that extension of the drive onto their property from the upper level was not done under a claim of right. And so, you know, every case that's out there having to do with this type of prescriptive use claim has some kind of element of hostility, and there just isn't any. And so when we go back to the records that we attached to our motion, where the Bruckmans have records of gravel dating back to 1994, and then the plaintiffs have nothing. I mean, the only thing that they've produced with regard to any kind of documentary evidence at all is the purchase of an Argo and a Kubota side-by-side. And so it just seems to me that there's just nothing. And so when the plaintiffs admit, yep, we're friends and we do it all together, and they really have no comeback even to anticipating their best argument. Gee, we bought in 1984 in land contracting, so we were there before you. But when Mr. LeBron testifies, I put up a lock and cable while I was there for the 6 years, and I never saw the plaintiff using it at all. Again, there's no continuous hostile claim of right, 15 years, et cetera, that the plaintiff would have to establish to take away a property right of the defendants. And so, again, when I'm glad that counsel for plaintiff attached the deposition transcript of Julia Halterman. So at page 25 of the deposition, she testified when I asked her a question about, how does the whole gate kind of thing, she said, normally we'd ask them, meaning the Comptons, permission to open the gate. Can you please open the gate? We need to get down. Well, my goodness, there is no hostility at all. If they're best buds with a 1/4 owner of the tenant in common property, then again, there is nothing that the plaintiff has shown, even an iota of a claim of right type thing to take away a property right.
So can I ask you, in your motion, you spend a lot of, you spend some amount of space documenting the friendship over the years between some of the parties. And at first blush, seems that plaintiff in the response was making a fair point that the hostility element is a legal term and not a term of emotion. So maybe you can help me nuance that. You're not saying that because they were friendly that defeats a claim of hostility, but that therefore it wasn't against their their interest under a claim of right because it was a cooperative use? Is that?
Yeah, so I think the case that they cited a couple times, that Munro versus Riddle case, was their primary argument with regard to, well, gosh, the one owner of the property knew that the drive to the neighbor cut across the corner, and they didn't do anything about it. They never discussed it. They basically let it go. But again, that was not a case that they're relying on. That was a shared driveway issue. And that's right. That's
But
right.
you'd acknowledge that hostile use doesn't mean angry use.
No, it doesn't have to
Unfriendly
be, it
use.
doesn't have to be in your face type thing, but it still, throughout every case out there, has to be inconsistent with the rights of the defendants in this case. And so, when there is, gee, we're having parties all the time, we're best friends, etc. And it just speaks to the volume of evidence that is on the defendant's side with regard to the permissive use. And again, the Munro versus Riddle case was just a corner of the property that was used exclusively or primarily by the neighbor. That's why I thought that case was easily distinguished. The only thing that I could add to what I tried to provide to the court is with regard to our claim for summary disposition on the riparian rights issue. I finally found a bigger, better plat that's clearer of Vincent's plat. I do have a copy of it I could share with the court. I had a really poor blow up copy, but here's the primary issue with regard to our trespass claim. I tried at Mr. Halderman's deposition to get him to appreciate the issue that the riparian survey was measured from the section line 105 feet. And so if you look at lot 15, can you see where there's a little arrow and there's 13.72 feet to the south of the section line? So that's where, again, I can't win a case at deposition. I just need to try to establish facts. And I finally raised the white flag and gave up trying to get him to appreciate that the riparian survey that we have prepared went 105 feet from the section line north to establish the fact that their dock was trespassing in the defendant's lake space. And so it's just a bigger, better, clearer issue with regard to what was the debate in his deposition of did their dock offend into the defendant's lake space or not. And then when counsel went ahead and argued, well, gosh, the dock isn't there anymore. I mean, everybody can see the dock that they've put back in. This year, they since the lawsuit was pending, 24 and 25, they put the dock out, they put the shore stations out, they've got the stuff in the water that they always had. So to argue that, it's not there anymore, it didn't make sense to me. I was really confused.
And your counterclaim, do I understand right, that's based on, well, here we've got this riparian survey and there's really no countervailing facts submitted by the plaintiffs other than saying they just disagree with it.
Correct, that's it. So, I mean, it was riparian surveys, as the court probably knows, are not cheap things. So we went ahead and had one commissioned in 2024. And again, the admission at the deposition was, the last 3 years, we've gone out from the same point just inside their property line and have angled out into the water. And so it just seems like, it may be not tens of thousands of dollars worth of damages, but obviously when they trespass and put their dock on the bottomlands of my client, and then, more boats on the side of the dock, it takes up more lake space. There is an element of damages to that. So I wish we would be all done here today, but I would ask that the court dismiss the plaintiff's complaint. And again, just set a hearing for our counter complaint for the riparian space intrusion.
Thank you. So I think in the interest of allowing a joint kind of response, I'd like to first next hear from Mr. Hanson on his concurrence in the relief, and then I can hear from you, Mr. Zayas. Go ahead, Mr. Hanson.
Your Honor, you indicated that you read the response and the amended response that incorporates the additional arguments that I thought were perhaps useful. And
yes,
I would again just emphasize that the relationship, friendly relationship between the parties is a central issue here in terms of the hostility that's required. Page 6 of my brief, I cited the Wango case in which the hostility issue, true owner must have actual knowledge of the hostile claim, or the possession must be so open, visible, and notorious as to raise the presumption of notice to the world that the right of the true owner is invaded intentionally with the purpose to assert a claim. We didn't have any testimony, Mr. Holderman or Mrs. Holderman, that they at any point got to, in their relationship with respect to use of this, where they announced that they were now claiming this is a hostile right. This is different than a neighborhood situation. This is more like a family situation. Can you have a family member living in your property with you for 25 years, file a claim for prescriptive easement to continue to stay in the property? I thought that the concept of unclean hands breaches that, which is why I agree with that. So I have nothing further to say.
Thank you, Mr. Henson. Mr. Zayas?
Yes, Your Honor, thank you. Again, Joseph Zayas on behalf of Mr. and Mrs. Holderman. And the first thing I think I want to point out is when counsel says that Mrs. Holderman testified about getting permission to go around the gate, that gate only went up 2 or 3 years ago. They have been using this road on a continuous basis for the last 40 years. And at the end of the 15-year period, that's when the right vests. So whatever happened after that gate went up is frankly irrelevant.
Well, I mean, it might not be dispositive, but it seems a bit much to say it's irrelevant, because if your clients had a claim, if she pulled up to a gate and said, open the gate so I can use this road, because it's, you know, if it wasn't some asking permission, the asking permission is, if we have a trial, that would come in at the trial because it would be relevant, right?
Yeah, it would probably come in, but I would argue that it certainly, perhaps I misspoke, Your Honor, certainly wouldn't be dispositive of whether or not it was permissive use or
I
not.
agree, yes. Okay.
Frankly,
But there's some evidence of it.
maybe.
She's asking permission. Why is she asking permission if she doesn't need permission?
Well,
That would
frankly,
be
I would
the-
argue, Your Honor, that that's more trying to keep the peace between the parties after they have kind of staked their claims and we filed a lawsuit trying to get this than anything else. I know the court certainly disapproves of self-help tactics. And once the gate went up, my client simply said, okay, we're going to exercise our rights under the court to try to get access to this road again.
Okay.
Now, my argument, Your Honor, is that at 15-year period, their rights vest. So, it's not evident, or it's not evidence of permissive use within that first 15-year period, certainly. And I think that's important to point out. So the most important thing here is I think we need to realize that we must take the facts in the light most favorable to my clients. We're looking for questions of fact here. And I think when you take the evidence in the light most favorable to Mr. and Mrs. Holderman, we see that they've been using this path since they purchased the property in 1984. They both testified very clearly to that. Now, counsel has attached an affidavit from a prior owner saying, well, he put up a string, he put up a gate. He certainly didn't, confront my clients with that affidavit during their deposition. If anything, he's created a question of fact, because my clients were very, very clear that they used that continuously since they bought the property in 1984 when they started to clear their property. So taking those facts in the light most favorable to Mr. and Mrs. Holderman, it establishes that they started to use that they continuously used that property. Now, if anything, what that affidavit does is show that use was hostile. It certainly shows that the prior owner didn't give any sort of permission for them to do so. Nothing within the affidavit suggests such a thing.
But even if you were right on that, that wouldn't establish the 15-year period is not established just through that.
No, I'm getting there.
So then, So how do you overcome the whether you call it permissive use or it wasn't hostile, it's sort of two sides of the same coin, where here's this outlot that by deed doesn't give your clients a right to use it. It gives these other folks a right to use it. And those other folks and your clients together are improving the roadway. You know, the owners are buying the materials and your clients doing some grading. They're all kind of using that together. How does that ever establish or ripen into any kind of hostile use? It seems at least some, even were there no words of permission, which there are some words of permission in this record, even if there were none, wouldn't that be a pretty clearly implied permissive use?
No, Your Honor, and I'll tell you why. Because cooperation does not equal permission. And there's no case law that says specifically that if the parties cooperate, that it has to be a permissive use as a matter of law.
Sure. I don't necessarily disagree with that, but as a matter of fact here, I mean, how is cooperative use inconsistent with the rights of the true owners or hostile to the rights of the true owners?
Because the Holderman's been using this continuously since 94 or since 1984, were doing so as if they had a complete right to do it. And nothing that the defendants did changed the manner in which they were using this, which was under a claim of right going back to 1984. So simply because the defendants get there and see the Holderman's using this prior, because I think the record is clear that the Holdermans were there before, simply because they were there before, simply because they said, okay, so you're using it, we're using it. If you do this, I'll do that. Let's come to an agreement on how this is all going to be maintained so we can have this great, happy lake life. That in and of itself doesn't change the claim of right that my clients had previously established. No time did the defendants in this action say, at least according to my clients, I know there's testimony on the other side about this agreement that they reached, which is slightly different than what counsel represented. It wasn't, we'll buy the things, you do the maintenance. The agreement that the defendants tried to push was in exchange for letting you use the property, the lot, this is what we'll do, this is how we'll maintain it. Well, my clients denied that that agreement ever took place. That being said, by the parties getting together and deciding how this is going to work, that doesn't interrupt their claim of right. In fact, it adds to it because it doesn't do anything. It accepts their use by that claim, and it doesn't do anything to stop that claim. It doesn't change the manner in which they were using it before.
So can I ask you then, and
Sure.
this ties in a little bit with Mr. Hansen's point, that an actual open, visible, notorious, hostile use can't exist only in the user's head, right? It has to be apparent to the world looking at the situation. Would you agree with that?
It has to be apparent, it doesn't have to be announced.
True, okay, but it has to raise the presumption of notice to the world.
Sure.
Right. So looking at this situation where they're doing this together, they reached an agreement about who buys the gravel, who does something with the gravel. They're all really friendly. Give me one fact in this record that outside of your clients, inside their own heads, would have given presumptive notice to the world, let alone to these co-owners, to the true owners, that your clients were operating under a claim of right. One fact.
They were using it since 1984, long before they got here.
Any of them got there?
Yeah. Long before any of the other defendants got there. They were using this property. And instead of saying, no, this is ours, get off, you can't use it anymore, they simply continued to allow them to do it for several years before this agreement even took place. So maybe I would agree with you, agree with the court, if it was a situation where maybe they all bought together, or my clients bought after them and said, hey, we want to use the road, we'll do this. But that wasn't the situation. For probably 5-6 years before any of these defendants purchased this property, my clients were regularly using that lot. And so when they get there and see my clients regularly using this lot, and in fact, Mr. Bruckman testified that no, he didn't give permission, he just kind of let it happen, which is eerily similar to the facts in the case I cited in my brief. We didn't just, the fact that that happens raises that notice that the court is referring to. And the fact that they did nothing to stop that, other than try to figure out a way to maintain it, doesn't establish the permissive use the defendants are looking for.
What am I to make of your client's, Richard's statement during his deposition that the only person who gave him permission was Chuck, the defendant, Mr. Gauthier?
He was referring to after the gate went up. He was referring to, if you read that whole portion of that deposition testimony, he was referring to after the gate went up, when Chuck came over and tried to give him a key to the gate that would allow them to go down at a certain point if they got permission. That's what he was referring to, but that was long after, any of this happened. That's in the last couple of years. The relevant portion that we're talking about here is approximately 1984 to 1999. And again, I think at that point, frankly, on advice of counsel, the Holdemans were advised and did not to take any self-help measures, but to try to let the courts handle it. And after the courts made their decision, then you would know what your rights were.
Okay. What about the dock, the trespass issue?
Yeah, so my client was certainly under the impression that he had 118 feet. The plat is what it is. I'm not going to say it's not. I will say this for the record. That dock, the start of it is where it is. But if you look at the repair and survey, it counts on the dock kind of angling over towards the Outlot A property. This summer, that angle was changed. So when I say it's not where it is now, and I think the reply brief still said the start of it, the angle changed, so it's no longer angling over into, even if you believe the repair and survey, is no longer angling over into where they are. So we're really talking about 3 feet for one summer.
Okay, well, that goes as to damages, but it
Sure.
sounds like you're maybe conceding that they're entitled to summary on that.
No, I wouldn't concede that they're entitled to summary on it, Your Honor. And if you look at the plat, what it's actually measuring, there's an extra, you see the 105 there going from one point to another marker, and then there's an extra like 13 feet on the other side there. And right above the 105. But my point would simply be, Your Honor, we don't have an affidavit from the surveyor. We don't have this deposition. All we have is, here's the survey. So
Which shows a trespass. So then once the moving party comes forward with that, doesn't the burden shift to you to come and either with an affidavit from a different surveyor or another survey or deposition or don't you have, isn't a burden shifted to you to show me why this is wrong?
Well, there are many ways to do that, Your Honor, and one is to show that the measurements are incorrect. Another is to show.
But you haven't done it. You don't have any facts or any evidence to do that. A lawyer's arguments. I mean, I'd never grant summary disposition if the moving party shows that they're entitled to it, and the non-moving party comes with no evidence to rebut it, except the lawyer's arguments that their evidence is wrong. Well, that's never enough, right? Are there any facts in the record to rebut the survey?
I would argue that my client's familiarity with his own property is evidence in our favor.
Complex, yeah. I'll grant you it's super complex because theoretically, we got to draw a line to the center of an inland lake. It's not a circle.
Right.
So I don't know how they ever do that, but the survey says they've done it, calculated the center thread of Burt Lake determined by the long lake method. So there's some thought that went into that.
Sure.
All right, anything else I need to know to understand your position?
I don't believe so, Your Honor. The rest, I believe, has been outlined in my brief.
Okay, thank you. I guess since the only moving parties are Bruckman and the Covetons and Cisco's filed a concurrence, but not a separate motion, I'll limit any rebuttal argument to you, Mr.
Thank you, Your Honor. I'll take the last point first. You look at page 73 of Julia Holderman's deposition. She admitted at her deposition that the dock of going out from the shore could be over into the defendant's lake space. So there was an admission to that as well. I just wanted to focus more on, in our motion for summary disposition, the issues of, did they ever establish 15 years of a hostile use? And so I still, after counsel has argued here, haven't heard anything that counters the issues raised in the two affidavits we filed. Mr. Gotham says the road was not passable with a vehicle until he improved it around 1989. And so, you know, could somebody walk down there and nobody saw him? Maybe, but obviously the owner of the property for 6 years, Mr. LeGrand, testified, I never saw the plaintiff at all, ever down there, except when I met him one time on the lakeshore. And I put up a cable with a lock on it to block any use. And so their claim of somehow their rights vested before our folks got there, I just think falls on deaf ears. They never took Mr. LeBron's deposition to try to establish that the affidavit was bad or anything like that. And then again, lastly, if you go back to the records, my client's records, the Bruckmans have a 1994, we contributed gravel kind of thing. And so 1984 to 1994 is only 10 years. There has never been established by the plaintiff a 15-year hostile that's ours for claiming it and let the world know. It just doesn't exist. That's why I think we're entitled to summary disposition.
Okay, thank you. Well, in this case, plaintiffs have sued for prescriptive easement and for trespass for entertaining with an easement to an access road to water over the defendant's jointly owned outlot property. Plaintiffs own property adjacent to that outlot. It is undisputed that the plaintiffs have used that access road across the outlot for several years, far in excess of the 15-year statutory period. The defendants, Bruckman, argue that this use was permissive, and they have depositions from several of the defendants that support this, depositions from other parties that are consistent with that theory as well. For example, about the road being impassable during certain time periods or not being used by the plaintiffs. The Bruckmans also say that the plaintiffs were allowed to use the access road in exchange for performing grading work on it, although defendants purchased the materials and then plaintiffs did the work, and the defendants have presented documentary evidence to support that arrangement. It's also undisputed that the relationship between the plaintiffs and at least some of the defendants was quite close over the years. Plaintiffs respond by saying, well, there's no agreement or permission to use the access road, and hostility for purposes of a prescriptive easement is not the same as emotional hostility. That of course is true, but the hostile use must be inconsistent with the rights of the true owners. It must be apparent that it's under a claim of right, and has been pointed out by counsel, it must be of the type of use that it would place the world and certainly the true owners on notice that this was happening. Here, the facts don't support this. The defendants have brought forth several facts, testimony, records of material purchased, affidavits about the installation of the access road and the lack of use by plaintiffs prior to that time. And plaintiffs have really done little more than simply deny that such an agreement took place. That is insufficient for the plaintiffs to meet their burden of establishing a genuine issue of material fact. Indeed, plaintiff's own testimony suggests the existence of permissive use. Plaintiff Richard Hullerman said the only person who gave him permission was defendant Chuck Houghton. Even if that was the only co-owner who gave permission, that alone would establish that the use was permissive, not hostile. Also, the defendants have shown defendants Bruckman have shown a clear trespass of riparian bottomlands of the plaintiff's dock. They've got the riparian survey documenting that, and plaintiffs have not raised a genuine issue of material fact to dispute this. They just disagree with the survey, but have presented absolutely no contrary evidence. Therefore, there's no genuine issue of material fact. Defendants Bruckman are entitled to summary disposition under MCR 2.116C10 of plaintiff's claims in the complaint. And they are also entitled to summary disposition under C9 for their counterclaim of trespass, except as to damages. So then we've got other procedural issues. The Coveton and Cisco defendants have concurred in Bruckman's motion. Their first response also affirmatively asked for relief from them, and the plaintiffs objected to that. And the Coveton and Cisco defendants filed an amended response. But in any event, MCR 2.116I provides that if the proofs show that there's no genuine issue of material fact, the court shall render judgment without delay. So requiring other parties to file motions that would lead us to the same point that we are today would be contrary to the intent of that court rule, and it would be contrary to sound concerns about judicial economy and litigation costs for the parties. So here, all the defendants, although not jointly represented, have the same property rights. There would simply be no way for the plaintiff to prevail against some, but not all of them. Therefore, under 2.116I, and in the interest of judicial economy, the court is going to sua sponte set aside the default against Doris Reeves and grant summary disposition to all defendants. Bruckman's may submit an order. Mr. Cleveland, as the prevailing party, you can submit an order to that effect.
We'll do so.
And then the only remaining issue will be damages for riparian trespass. So we should set that for the final pretrial. So why don't we schedule final pretrial October 13 at 9:10 a.m. That'll be on limited to damages on the counterclaim. And parties may appear in person or by Zoom at their option at that.
What time again? I'm sorry.
October 13 at 9:10 a.m.
Okay.
All right, thank you all. Okay.
Thank you. Thank you.
Did you want this larger?
I'll take it
back.
Thank you. Yes. Quit blocking there. I'm sure I look pretty dangerous.
Now we're going to move into family division of 5 students.
On June 16, 1944, a 14-year-old boy named George Stinney was executed.
Are you Mr. Fisher?
Yes, sir.
You think that's a good shirt to show up in court for?
No, sir.
Okay, why don't you change and call back in?
All right. Sorry.
I'm gonna put you back in the waiting room and we'll take another matter first. Tell the guys. What is your name, sir? What's your name, sir? Yeah, what's your name, sir?
Oh, my name is Stephen Kaler.
Okay. Why don't you come
I'm
on up?
president only as an observer.
Oh, okay. Okay.
I guess while we're waiting, Judge, we might be able to address a couple of matters before the court that are scheduled for later on. That would include Mr. Taylor's case, scheduled for 11:20.
Okay, grab those. All right, so the two files with Mr. Nathaniel Kaler. Yes,
Your Honor,
Mr.
I
Keel?
believe you do have a potential resolution, although Mr. Taylor has requested at this time that he be allowed to screen for the recovery court program. This is a relatively new request. We just came to a resolution on this not long ago, so we're asking the court to adjourn this matter out for a few weeks so that he can be screened for the recovery court program. He's currently incarcerated. I guess he would remain there until he was screened. So to eliminate the need for him to appear in court today, we would just ask this matter be adjourned out until, I don't know, maybe early August so that he could be screened for that program.
Okay, any objection, Ms. Goodrich?
No objection.
Okay, so we will not need Mr. Kaler brought out. Mr. Kaler's cases, files 216133FH and 6134FH. We're going to continue the docket calls to allow him to apply for the 53rd Circuit Recovery Court program. And we'll continue both of those to August 10th at 10:40 a.m. And we'll have those scheduled in person in the courtroom. Anything further on those files, Mr. Keel?
No, Your Honor.
Okay, Ms. Goodrich?
No, Your Honor.
Okay, so sir, the case will be adjourned to August 10th. Have a good day.
Your Honor, we also have a matter scheduled for 11:30 for a Frankie Weiser.
Okay, that's file 21-6129, Mr. Schweizer. I have a note that he's in a residential Veterans Administration Treatment Center in Battle Creek. Is that correct?
That is correct, Judge, and we sent the paperwork in verifying that. It's also had his bond, I believe, amended. So we would ask that the docket call be scheduled to August so that he can complete that residential program.
Any objection, Ms. Goodrich?
No objection.
All right, should we put that out to August 31?
I think the 10th should be fine, Judge. I think we could resolve it then. That looks fine.
Okay. Do you know, is he, let's see. Okay, so he's in Northern Michigan, isn't it? Do you have a preference whether that would be in person for Mr. Schweitzer or Zoom for him?
I guess we would just ask for Zoom at this time. We can always amend that if he's in a position to show up in person, but obviously it'll be easier for us.
Any objections, Mr. Speaker?
No objection.
Okay, we'll continue this docket call then to August 10th at 11:50 a.m. but allow a Zoom appearance. Thank you, Mr. Soulier in the Zoom room from the jail.
The police don't want you to know this, but the reason we always ask for your insurance is because we know with the cost of everything rising in
All right, we're next up. People of the State of Michigan versus Christopher Soulier, file 21-6091FH. We have Mr. Soulier from the Sheboygan County Jail by video. His attorney, Mr. Keogh, is present in the courtroom, or I'm sorry, is present on Zoom video, and the prosecuting attorney, Ms. Goodrich, is present in the courtroom. We're providing public access online. This is the time and date set for a docket call and bond violation hearing. Mr. Keogh, do you know how we're proceeding?
At this time, we don't have a resolution in regards to the docket call. In regards to the bond violation hearing, we would like to proceed with that at this time.
Okay. So we'll have to take some testimony about the missed test. Is that correct?
Yes, Your Honor.
Okay. Well, let's handle Fisher case and the court staff come out for testimony for that.
Thank you, Your Honor.
So sit tight, Mr. Soulier. Let me go off the record for a minute. All right, so we're back on the record. We're calling the case of People versus Alexander Fisher. It's file 18-5567FH. We have Mr. Fisher present by Zoom video with us. Mr. Keogh, for purposes of initial hearing attorney, is present as well. And we have the prosecuting attorney, Ms. Goodrich, present in the courtroom. And we're here today, we are providing public access online as well. We're here today on Agent Fagan's petition to extend the term of probation by an additional year to maintain jurisdiction and supervision due to pending criminal charges in Otsego County. And the new expiration date would be September 18th, 2022, when currently it's set to expire on September 18th, 2021. So Mr. Fisher, normally in the past, this would have just come to me and I would have signed it. Under the new criminal justice reforms, probation extensions do, I believe, require a hearing, although the law is not entirely clear on that. So we're affording a hearing on this for you to be heard as to your position on it. So Mr. Keogh, do you know if Mr. Fisher has any objections to the extension?
I do not, Judge.
Okay, Mr. Fisher, do you have any objection to continuing your probation for a year to find out what happens in the, what's that?
I said, yes, I do, sir. I've been very good. I've done everything my probation officer has said. I've never missed any time. In fact, I'm early. I'm the first guy at the door. You can ask him in Grayling. And this is just a mistaking of identity. It's cost me $4,000 to prove my innocence. And I'm going to a jury trial. I did not do it. I would not have spent $4,000 to prove my innocence for an $800 offense that I did not take.
What is the offense that's pending in Otsego County?
The offense is they're trying to say that it's larceny over 200, but under 1,000. It was a fence that was taken by somebody, not me.
Okay, well,
and I have that I was on a golf course cutting grass at the time.
Okay. Well, Mr. Fisher,
virus, that's why it's extended due to the virus. Otherwise, it would have been done already.
Okay. Well, Mr. Fisher, I will
have
tell
signed
you
documents from people and everything.
Okay, Mr. Fisher, I will tell you that it has, in fact, been reported to me by the probation officer that you have done well on probation. But we also have a pending criminal case.
I've tried my hardest. I have been taking my medication. I've been working, eating, sleeping. I've stayed out of trouble. And like I said, this is mistaking identity. I didn't do it, Your Honor.
Well, Mr. Fisher, let me put it to you this way. So as far as I know, you're doing fine on probation, but there's an allegation that you have committed a new crime in Otsego County. I understand you got the right to be presumed innocent and you're asserting your innocence and going to a jury trial. So I have two options. I can't exactly discharge somebody on probation successfully if there's pending criminal charges against them. So I have two doors I can go through. One is to violate your probation right now in Sheboygan County because you're alleged to have committed new crimes. And then we go down the violation door. Door number two is to extend your probation to see what happens. And if you are in fact found to be innocent, then we'll just discharge you as successful. If you're found to be guilty, then we'll have to deal with it at that time. So understanding that those are the only two doors I have, to violate you right now or extend it and see what happens. What door do you want me to pick?
I want to go door number 2 because I know I'm innocent and I'll be let go.
All right. Mr. Keough, anything further you wish to be heard on it? Okay, you're muted, but I could read your lips to say no, thank you.
No, Your Honor. Thank you.
Okay. Ms. Goodrich, any position from the people?
I'm in agreement with the extension.
All right. So, Mr. Fisher, and I want to assure you, we're not doing this because we thought you were doing bad on probation. We're just doing this because we'd rather do this rather than violate you right now. So I am going to grant the probation department's request to extend your probation a year. But I'll indicate, as soon as we know what's going on in Otsego County, if that case is resolved, we'll discharge early. I don't need to keep you on. I just want to keep you on long enough to know what happens in that case. Okay?
Thank you very much, sir.
They must stop giving conservatives this free gold Trump survivor coin.
Okay, you have a good day, sir.
You too, sir.
All right, so we're recalling the case of People of the State of Michigan versus Christopher Soulier. And we're here for a contempt hearing for allegations of bond violation. So, Ms. Goodrich, do you wish to call a witness?
I do. I wish to call Melissa Royal, please.
Ms. Soils, please come up to the witness stand here. Please raise your right hand. You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help God. Will you be seated? Go ahead, Ms. Goodrich.
Can you state your name for the record, please? Melissa Royal. And where are you employed? And what is your position?
I'm the collections and bond compliance clerk.
This is part of your employment duties. Do you monitor the drug bond line? And how do you do that?
It's online and I just check it daily. For any missed calls, any missed tests.
Okay, and in the Christopher Soulier matter, did you do a motion order to show cause? And was there one dated April 15th, 2021, signed by you on that date?
I believe so.
And what were the missed tests on that one? If you need to refresh your memory.
Well,
Your Honor, could I ask the witness to speak up? We can't hear her very well.
Okay, that's fine. This is scheduled to be held in person, so if you were in the courtroom, Mr. Keough, you'd probably hear it better.
That's true, Judge.
But I'll ask the witness to speak up. All right.
I believe that's what it is.
Okay, so on April 15th, when you filed the motion to order to show cause, were there 2 missed scheduled tests on that date? And was that April 10th and April 14th?
That's so.
Okay, I know that you were not noticed that this was going to be running. Do you have your records in front of you? Okay, would it be easier just to list the dates?
I guess if that's
okay. If you can list the dates of missed tests.
Okay.
By Mr. Soulier. Okay. Can we take a break, Your Honor, so she can grab the documentation needed?
Okay, the witness is asking to refresh her recollection by looking at some records that she did not bring with her in the courtroom. Any objection, Mr. Keough?
No, Judge.
Okay, so we'll pass this case momentarily. Please sit tight, Mr. Keough, or Mr. Soulier. We'll put you back in the waiting room. And Mr. Keough, we also had People v. Beaugrand up at 11:10 a.m. Do you know what's going on with that?
I know that I spoke with him. He was aware of the hearing today. My phone's been ringing off the hook since I've been on with the court. I don't know if that's him calling my office or not, but I tried to leave a message for him, was unable to do so today. I did send him an email.
Okay, so I'll pass on it to the end of your docket, to give them every opportunity to appear then.
Thank you.
All right, we'll recall Sulier and resume the stand.
Okay. Oh, yes.
So we're recalling the case of People v. Christopher Sulier. Go ahead with your direct examination.
Thank you. Do you have Mr. Christopher Slio's records in front of you? Okay. And if you could let us know what is showing as a missed scheduled test, what dates?
Yes, April 10th and 14th.
And were there any missed tests?
Looks like there was one, well, I'm sorry, those were missed, there were 2 missed tests on that original show.
Okay. And if we could just go over the 3 show causes now, were there other missed tests since April 10th and April 14th?
This is the additional bond violation. It would be April 23rd, April 26th, and May 15th.
Okay. And then was there a 3rd bond violation filed on June 22nd?
Yes.
And were there missed scheduled tests?
Yes, there was 3. May 25th, June 11th, and June 19th.
And between the 3 bond violations, were there any missed calls?
I believe so on the original show cause from April 20th. There was 2 missed calls, April 14th and 18th. And first additional violation.
Is that the one dated May 17th?
Yes.
Okay. What were the missed calls on that?
April 20th, 21st, 30th, and May 7th.
And were there any positive tests among the 3 violations?
On the April 20th show cause, there was an abnormal test, April 13th.
Okay. What about on the May 17th show cause?
Watch what peanut butter does to our body.
Celery with peanut butter. Peanut butter is one.
Yes, May 5th.
And June 22nd?
On June 1st.
And what were the tests positive for? Was it the same substance or different?
I believe it was the same substance.
And what would that be?
Can I refresh you?
Yes.
April 13th, buprenorphine. All the same. It was all for people.
Okay. And since filing these show causes on April 15th, May 17th, and June 22nd, has Mr. Sulier provided you any prescriptions or any documentation to show he has prescriptions?
Yes.
And since the date of filing these 3 show causes, has he provided you any proof of taking any tests or calling into anywhere else?
No.
Thank you. No further questions.
Cross-exam, Mr. Keel.
Ms. Lael, were you made aware that Mr. Sulier did test on June 11th and provided a receipt from advanced drug testing to the circuit court the last time we were in court?
I do not have those.
Has Mr. Sulier been in touch with you personally in regards to some of the issues that have come to light during the course of his bond?
He has not that I recall.
And how did you receive information about his prescriptions?
I believe it was discussed in court, but I don't remember him calling at all about the prescriptions.
But you indicated that he did have a prescription for the buprenorphine?
We have discussed it in court, but sorry, I can't recall if he does or not. I don't have that in my file, so it doesn't show that he does.
Thank you. I have no other questions.
Any redirect?
No redirect.
Okay, thank you. You can step down. Any further proofs, Ms. Goodrich?
No further proofs, thank you.
Mr. Keough, any proofs?
Mr. Sullier would like to make a statement to the court in regards to his bond violation allegations.
Do you mean you
Yes,
wish to
sir.
offer any test? Hold up. Are you, I mean, we're in a hearing, so we're not accustomed to just folks making statements. Does he wish to offer some testimony under oath and be subject to cross-exam?
Sure, that's fine, Judge.
Okay. Mr. Sullier, would you please raise your right hand as best you can? You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, you put your hand down. Mr. Keough, go ahead.
Mr. Sullier, there have been a number of show causes that have been scheduled during the course of your bond conditions for missed and missed scheduled tests and missed phone calls and abnormal tests on June 1st, 2021. Do you dispute that you missed some tests during the course of your bond?
No, I do not.
Okay, and why did you miss the test to your recollection?
I had no money.
Okay, and did you contact the court in any way to let them know that you didn't have enough money to submit to the test?
No, I did not.
Okay, and as far as the missed calls, any explanation for the missed calls?
Just getting them right at the beginning, getting used to the routine. I missed a couple calls, getting in on time. I had a phone issue that I was trying to use a phone app to call, and it took way more time than I expected to get through, and I missed my 10 o'clock time mark.
And in regards to the abnormal test on the 1st of June, do you have any explanation for why that test came back diluted or abnormal?
Probably just because I had to drink water just so I could pee. I'm diabetic, so like I'm up all night long peeing, and if I don't drink water, I'm not gonna pee in the daytime. So when I have to test, I have to drink water so I can pee, and a lot of times I can barely pee before the test.
Thank you. I have no further questions.
Any cross-exam?
No, Your Honor.
Any further proofs, Mr. Keough?
No, Your Honor.
Closing arguments, Ms. Goodrich.
Your Honor, I believe in defendant's own statements, he admits to missing tests, missing calls, and testing positive, or including missing tests, and just offering an explanation of those things.
Thank you, Mr. Keough. Closing argument.
Your Honor, I guess it would be our argument that Mr. Sullier does have a reasonable excuse for not testing based on lack of funds for those missed tests that he spoke of. In regards to the abnormal tests and as far as the missed calls, no argument in regards to that. Thank you.
All right. Well, I am going to find Mr. Sullier in contempt. I think that there is proof beyond a reasonable doubt of that, not only from the testimony of Ms. Leo, but also from the statements of the defendant himself. He acknowledges missing some tests, missing some calls. You know, I'm not even considering the positive test because he has the prescription for buprenorphine that his counsel has told us about. I'm accepting that to be true. But Mr. Sullier, you know, who has quite an extensive criminal record, I was persuaded to reduce his bond earlier in this case and place him out in the community. And given his prior record and the charges in this case, for the safety of the community, we require that he calls in every day and submits to random drug and alcohol tests. And for a big chunk of time, he just wasn't calling at all, wasn't testing at all, missed a bunch of them. And then he says, well, I don't have any money for the test. He didn't tell the court at the time, didn't tell his lawyer, didn't come up with a solution to the problem. I mean, my goodness, if I said, oh, okay, I think every single defendant who has the drug test would all of a sudden stop testing. and say, oh, yeah, I didn't have money. Before we would make a finding on that, I mean, I'm sure that Mr. Sullier made some purchases over the last, few months. He's just not made any effort to comply. So I do find him in contempt of court.
Hey, this is Senator John Ossoff in Georgia, and before you skip this ad, I've got this FEC deadline.
Any comments with regard to sentence, Ms. Goodrich?
Your Honor, I'd ask for the 93 days.
Mr. Keel?
We would ask the court to consider time served in this matter. I would bring to the court's attention that Mr. Sullier does have a surgery that's scheduled for the 15th at McLaren, Northern Michigan. We have provided information to the prosecutor and to the court in regards to that matter. We believe it's important for him to at least get a furlough to be allowed to have that surgery take place. So any sentence we would ask would include a furlough to allow him to get that surgery. Thank you.
All right, Mr. Sullier, it's not required that you would make a statement, but is there any statement you want to make to me with regard to what I should do about your contempt?
I'd like to apologize, Your Honor. I was doing the best that I tried, and I never thought of calling the court. I talked to Mr. Keel about it when he messaged me about the things, the violations. I just never thought about calling the court saying I didn't have the money, and I heard you say something about a prescription. I know I did have my pharmacy fax her prescription. I don't know whatever happened to that, but I brought another one in the day of court.
Okay, thank you. Well, I'm going to, on the contempt, sentence Mr. Sullier to 93 days in the Sheboygan County Jail. He gets credit for 14 days previously served because I revoked his bond on June 30th. The bond continues to be revoked. So what will happen is once he serves the contempt sentence, then his bond is still revoked, but at that time, Mr. Sullier can petition for reinstatement of bond and the court would consider it at that time. But he won't be released until he serves the contempt and then we have a motion about reinstatement. And in terms of the surgery, I mean, I was handed today a document for an ambulatory surgery.
Damn it.
It doesn't have a whole lot of detail to it. It's not a whole lot of information to it. I'm not a doctor, but it sure doesn't look like it's, super medically necessary. I'm going to entrust that to the jail. They have nurse and medical services in there. If there's a medically necessary service that Mr. Sullier has, then he's going to receive it. And I'm going to get a request from the jail administrator for a medical furlough. But just because he had something scheduled before his bond got revoked does not make it a medical necessity. So I'm not going to enter any furlough at this time. He'll remain in Sheboygan County Jail. As to the docket call, Mr. Keel.
Your Honor, I guess we have this matter set on a trial path, so we would just ask that we have this matter scheduled.
Okay. Let me add into our list. In terms of the age of the case, looks like the preliminary examination was held on February 12th of 2021. Mr. Sulier's been in custody since June 30th. How many days do you estimate for trial?
Introducing the only prescription hair regrowth gummy on the market, the Minoxidil Plus Biotin Gummy by Hers.
I believe we thought 2 the last time we were in court, and I think that's fair.
Does that include the jury selection?
Probably not, probably 3. If we include the jury selection, that'd be day 1 and then 2 days for the trial.
3 days, including jury selection. Thanks, advice, Ms. Whitty.
Thanks, more than enough.
Okay, we do have a couple cases that have been pending longer on the jury trial waiting list than Mr. Sulier's. So I've added them to the list. And what I'll do is I'm going to continue the docket call then to August 10th at 10:30 a.m.
Your Honor, I just noticed on my schedule, and I had a few matters that were scheduled on the 10th today. I just realized that I do have a jury trial that's scheduled in another county that day, so I guess I would ask if that could be put at a later date.
Okay. Set this for August 31st at 10:30. For a docket call in person. Anything further on this file, counsel?
No, Your Honor, thank you.
Ms. Goodrich?
No, Your Honor, thank you.
All right, Mr. Sulier, we'll see you at the end of August.
All right.
And Mr. Bogrand, Mr. Keough, you have any word on him?
I do not. At this time, I was going to make another phone call and check my voicemail and see if he's reached me. I do have Mr. Pulowski that is scheduled for a arraignment and a plea. So I don't know if he's currently in the jail. We have submitted the plea paperwork to the court. I can attempt to call Mr. Bogrand again while Mr. Pulowski is being brought into the court.
Your Honor, Mr. Keough was a jury trial on August 10th. Do we need to reschedule Keeler, Schweitzer, and Christopher?
Well, he also has 3 other matters already filed, so I'm not going to go back on the record and tweak all those. We'll have to get a stiff or something. So, Mr. Keough, if it looks like your trial on August 10th is going to go, we already had some things already set for you that date, and now others we've added today. So we'll have to get a, global stipulation from you or something.
That's fine, Judge. I'll
work with the assignment clerk to find new dates for this thing.
Very good. Thank you.
So we can put Pulowski in the Zoom. We can go off the record for a moment. Keough here. All right, we're on the record in People of the State of Michigan versus Stephen Pulowski. We have 3 files up, 21-6128FH and 6136FH were scheduled for sentencing. We also have an arraignment on a new charge, 21-6166FH. And Mr. Keough, has Mr. Pulowski been provided with a copy of the felony information?
Yes, Your Honor. We would waive the formal reading of the same and ask the court to enter a plea of not guilty.
And is a forensic center referral requested?
No, Your Honor.
All right, and do I understand that there is a plea to be entered today to the charge with sentence recommendation for Sheboygan County Recovery Court?
That's correct, and restitution of $20.
Okay. Mr. Pulowski, you wish to enter a plea according to the terms of that agreement?
Yes.
Please raise your right hand, sir. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, put your hand down. Would you state your name for the record?
Stephen James Pawlowski Jr.
Mr. Pulowski, this is an important hearing because you're waiving constitutional rights you have, so listen carefully. If you need to speak privately with Mr. Keough at any time, you just say so. You understand that?
Okay.
You're offering to plead guilty to a charge of delivery of buprenorphine as a habitual offender 4th offense. That is a felony crime with the habitual. It's punishable by up to life in prison and or a $10,000 fine. And unless you're sentenced to more than a year in prison, the court will impose sanctions on your driver's license. Do you understand the maximum that you should face?
Yes.
Are you on probation or parole anywhere?
No.
Now, this offense is alleged to have occurred back in March of this year. Were you on bond for any other case at that time?
They're legally stealing from you. And when my husband exposed this as a sheriff, we started getting...
No.
You understand if your plea is accepted, you won't have a trial of any kind and you'll be waiving your trial rights?
Yes.
Did you read and understand the rights listed on the advice of rights form?
Yes.
Did you give Mr. Keough permission to sign your name to that form?
Yes, sir.
And do you understand that by pleading guilty, you're giving up the rights listed on that form?
Yes.
Is that what you wish to do today?
Yes, sir.
You understand if your plea is accepted, you're giving up any claim that it was caused by promises or threats that no one tells me about today?
Yes.
You're also giving up any claim that it was not your own free choice to enter the plea?
Yeah.
You understand by pleading guilty, you waive the right to appeal. And if you wanted to appeal, you'd have to get permission by filing an application for leave to appeal. Do you understand that?
Yes.
And also, the types of issues you could raise are more limited. A guilty plea waives some issues entirely. Do you understand that?
Yes.
There's a plea agreement in exchange for your plea of guilty to delivery of buprenorphine habitual 4th, payment of restitution of $20. The prosecutor will dismiss the drug double, and there's a sentence agreement for Sheboygan County Recovery Court. Do you understand the terms of that plea agreement?
Yes.
Mr. Keough, is that a full, fair, and accurate statement of his terms?
It is.
Ms. Goodrich?
Yes.
Mr. Pulowski, do you understand that that sentence agreement for recovery court program is not binding on the court? If at the time of sentencing, I decided it wasn't working very well and didn't want you to be in that program, I wouldn't have to allow you to continue it. Do you know that?
Yes.
But if that happened, you'd be given the right to withdraw your plea. Do you understand that?
Yes, sir.
There's a very, very important exception to that. I want to make sure you understand. If you engage in misconduct between now and the time of sentencing, say you engage in new criminal conduct, you violate a condition of bond, or you fail to appear for court or abscond, by your misconduct, you'd be forfeiting the right to withdraw your plea, even if I don't follow the sentence agreement. Do you understand that?
Yes.
Other than the terms of the plea agreement, has anybody promised you anything to get you to plead guilty?
No.
Has anybody threatened you?
No.
Is it your own free choice to plead guilty?
Yes.
Knowing all this, how do you wish to plead to the charge of delivery of buprenorphine?
Guilty.
So back on March 12th of 2021, were you in Sheboygan County?
Yes.
Did you deliver buprenorphine to a person that later turned out to be a confidential informant with SANE?
Yes.
And did you know that the substance you were delivering was buprenorphine?
Yes.
Did you have permission to deliver that substance to anybody? You don't have a medical license to prescribe that, do you?
No.
All right, and did that delivery take place in Sheboygan County?
Yes, sir.
Do you have some previous felony convictions? In 2004, were you convicted of larceny in a building in Sheboygan County?
Yes.
In 2014, were you convicted of 2 felonies of delivery of manufacture of less than 50 grams of a controlled substance?
Yes.
So you acknowledge you have at least 3 prior felonies?
Yes.
Mr. Keough, you satisfied with the factual basis?
I am, Your Honor.
Ms. Goodrich?
Yes, Your Honor.
Mr. Keough, are you aware of any other promises, threats, or inducements?
I am not, Your Honor. Thank you.
Ms. Goodrich?
No, Your Honor.
And Mr. Keough, in your judgment, has the court fully complied with the requirements of MCR 6.302?
Yes, it has.
Ms. Goodrich?
Yes, Your Honor.
Mr. Pulowski, we've given you a lot of information. It's possible that may have caused you to change your mind. So I ask you once more, how do you wish to plead to the charge of delivery of buprenorphine as a habitual offender court?
Guilty.
Well, sir, I find that your plea is knowingly, understandingly, and voluntarily made, and that there's a sufficient basis in fact and law to believe you're guilty of that crime. So I hereby accept your plea. I think what I'd like to do is, you're also up for sentencing on the first 2 charges that we're going to bring you into recovery court.
In other news, a 2025 DOGE inspired initiative is causing a stir with the release.
And then this is a straggler case that SANE had. So I'd propose that we would adjourn the sentencing on the 2 files and set this for sentencing at the same time. Any objection, Mr. Keough?
No, Your Honor.
Ms. Goodrich, any objection to that approach?
No objection.
How about we schedule it for July 27th then, just a couple weeks out? Mr. Fagan, would you be able to get a PSI on the new one?
Sure.
Banged out?
Yeah.
So we'll schedule this for a sentencing on July 27th at 11:40 a.m. in person on all 3 files, 6128, 6136, and 6166. And Mr. Keough, do you have any requests with regard to bond?
Yes, Your Honor. We would ask the court to consider amending bond in all 3 cases to a PR to allow Mr. Pulowski to begin this recovery court program. We do think it makes sense, since he will be residing apparently at the tea house, that that bond be amended so that when the tea house bed is available, that the bond would be amended to a PR. I just want to make sure that he's placed in a good position so that he has the best chance of success once he's released from the jail. Thank you.
Ms. Goodrich, any position with regard to bond?
No objection to that.
Okay, Mr. Pulowski, I'm going to amend your bond in all 3 files to reinstate a personal recognizance bond of $5,000. So that's just a recognizance bond. You don't have to post that. In all 3 files, it'll have recovery court conditions. We're going to try to push that paperwork through to get you released this afternoon so that you can meet with the Salvation Army and get situated at the transition house. Okay. Immediately upon your release, you're to contact Ms. Pulowski and get situated with the transition house. If something happens where you can't get there tonight, you're to coordinate with her for where you're to stay tonight. And we did this a while back, and within 24 hours you were back in. So we don't want to repeat that. All right, Mr. Pulowski?
No, you don't.
Okay. All right. This program would be a good program for you if you're committed to trying to beat back this monster. Okay. But we need you to keep it together for longer than 24 hours. Okay.
Right.
All right. So we'll do that. We'll adjourn the sentencing and set them all for July 27th, and I'll amend the bond in all 3 files. We'll get you out and get you working the program and get off to a better start. Okay, Mr. Crosby?
Okay, thank you, Your Honor.
Okay. We'll adjourn the bond violation hearing as well to that same date and time, Mr. Keel.
Very good. Thank you very much, Judge. I was able to get a hold of Mr. Bogrand. I believe that he may be in the waiting room on Zoom.
Okay, he's not yet there.
I'm just going to mute myself and try to get a hold of him again.
Okay. We'll go off the record momentarily, see if we can get Mr. Bogrand in.
This is breakfast.
Let's see, there we go. So that's it for today, ladies and gentlemen. Just a reminder, if you're not a subscriber to this channel and if you like the content on this channel, please consider subscribing to this channel. By doing so, you are helping this channel grow and you're helping this platform grow. I put a poll up in the posts. What time do you think I should start? 3 o'clock, 4 o'clock, or 5 o'clock? It seems that too many people are streaming during the time that I'm streaming, and I want to try to rectify that. I'm also trying to keep these within the 2-hour limit. And if you're enjoying this content, please let me know that you're enjoying this content. I don't know. Let me hear from you. Tomorrow is our miscellaneous case. So it's just a bunch of different judges and different cases and stuff. Sunday is our landlord-tenant docket. I posted the schedule in the community post, what Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, and Sunday is. So that everybody knows this docket is this judge and this judge and this judge and this judge and this judge. Well, that's it for me today. You all have a wonderful evening. I will see you guys tomorrow. Ciao, ciao, ta-ta. Have a good evening, and I'll see you again tomorrow. Bye-bye.
Right. ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do, from the highest peak, I can see it through. With your care and touch, everything's okay.